Section 4 of Tribal Custom in Anglo-Saxon Law by Frederic Seebohm. This LibriVox recording is in the public domain. Chapter 2, The Summary of Cymric Evidence, Part 2. The fiscal unit for the purpose of food rents to the chieftains. The structure of tribal society in Wales is one thing. The practical working of its rules is another. Until we can to some extent realize its methods and see how its results could be worked out in everyday life, it must remain to some extent vague and mysterious. The nearer we get to its core, the greater its value as an instrument in further research. We cannot, therefore, afford to disregard any hints that the codes and surveys may give us, attention to which would help us to realize its methods or ways of working. The Denbigh extent, as already said, enables us to realize that, on the English conquest, the lordship of Denbigh was divided into grazing districts which had become the units of tribal food rents, and which were adopted for purposes of future taxation. These districts were called by the scribes villatae, and were occupied by gwellies of tribesmen and sometimes also by gwellies of non-tribesmen. Their homesteads or huts were occupied in severalty. Their grazing rights were undivided common rights, and within each gwelly the rights of families and individuals were also undivided common rights. Further, the Denbigh extent shows how easy it was to shift the whole body of tribesmen of this or that gwelly, with its herds, from one district to another, according to convenience or the needs of population, without disturbing the complex rights within the gwelly. The families and individuals carried their rights, inter se, with them wherever they and their herds might go, and were liable to pay the dues required from whatever villata for the time being might be occupied by them. Even the homesteads of the tribesmen seem to have been temporary, in the light of the description given by Giraldus Cambrensis. They could carry their hearthstones with them wherever they went, so that the result seems to be that the groups of kindreds could always have been easily shifted about, as they were in fact after the English conquest, from one district or villata to another. The geographical divisions thus became the permanent fiscal units in tribal arrangements. Both in the surveys and in the codes we find the villata or district, and not the family group, the fixed unit for tribal food rents to the chieftain, and for taxation after the English conquest. The surveys so far agree with the codes. The villata of the surveys was the taxable unit, and in some cases still paid the tunk pound, or 20 shillings, in lieu of the chieftain's food rents. In other cases, escheats and other causes had varied the amount. In the codes of South Wales, the unit for the tunk pound was the trev, and in the Venedosian code of North Wales, the manor of 4 trevs. Now, as in the surveys, the family groups or gwellies were located so as to occupy sometimes several villatae, and sometimes undivided shares in villatae along with others. So, if we may take the villata of the surveys as equivalent to the trev or manor of the codes, we must expect to find that the kindreds of tribesmen at the period of the codes were scattered in the same way over the trevs and manors. And as the manor was a group of trevs, the trev is the unit of tribal occupation as to which a clear understanding is most necessary. In this, however, we may be, after all, only partly successful. The word trev, though generally used for a homestead or hamlet, seems from its other meanings to involve the idea of a group. There were cases in which a disputed matter of fact had to be established upon the evidence of men of the Gorva trev, i.e., by men of the groups outside the trev in which the question in dispute arose. And this Gorva trev was not merely the next adjoining trev or trevs, but it consisted of those randiers or divisions of neighbouring trevs, of uchelors or tribesmen, whose boundaries touched the trev in which the disputed facts arose. Neighbouring randiers of teog trevs, i.e., the trevs of non-tribesmen, were excluded, presumably because the testimony of teogs in matters relating to tribesmen was not relied on. But this compound of the word trev implies that its general sense was a group of homesteads. That, in general, trevs had defined boundaries is clear from the fact that it was an offence to break them, and this applied also to the randiers or divisions of the trev. Speaking, then, of the group generally known as a trev, we must regard it not only as a taxable area, but also as the natural group known everywhere as a trevgordd, i.e., the natural group of the homesteads of relatives or neighbours acting together as a single community as regards their cattle and their ploughing. The typical lawful trevgordd is thus described. Quote, "This is the complement of a lawful trevgordd, 9 houses and 1 plough and 1 oven, or odin, and 1 churn, or gordd, and 1 cat and 1 cock and 1 bull and 1 herdsman." End quote. There is another passage which mentions the 9 buildings in the trev. Quote, "These persons do not forfeit life. The necessitous for the theft of food after he has traversed 3 trevs and 9 houses in each trev without obtaining a gift though asked for." End quote. So, in case of fire from negligence in a trev, the holder of the house in which it arose was to pay for the damage to the next houses on each side if they took fire. And again no indemnity was to be paid to the owners in a trevgordd for damages from the fire of a smithy if covered with shingles or tiles or sods, nor from the fire of a bath, provided always that the smithy and the bath were at least 7 fathoms from the other houses in the trevgordd. The description above quoted of the normal trevgordd suggests that the herd under the one herdsman did not belong to one person or homestead, but to many, and so far it seems to be consistent with the surveys which represent the villetae as occupied by the cattle of several family groups who had grazing rights therein. And this too accords with what the Denbigh extent tells us of the individual tribesmen, that is, that only some of them had homesteads. So and so habet dormum, or non habet dormum. The young tribesman with his dar thus may have joined in a common homestead with someone else, probably with his parents or near relatives. Distinguishing then the trev as a taxable area from the trevgordd, and still confining attention to the trevgordd as a cluster of homesteads, united for the practical purpose of occupation, let us recur to the things which bound the trevgordd into one group, that is, the 1 plough, the 1 oven, the 1 churn, the 1 bull, and the 1 herdsman. Here are the 2 elements combined of pastoral and agricultural cooperation, and the trevgordd is the local and physical unit of this cooperation. Taking first the pastoral element, the trevgordd was a working unit of cooperative dairy farming. The cattle of several households or individuals were put together in a common herd with a common bull and under the care of a common herdsman, or beguile, and his dog. It may be regarded as a group of the homesteads of the persons in charge of such a herd, and the tribesmen of a gweli may have cattle in the herds of more than 1 trevgordd. 3 things were ornamental to a trevgordd: a book, a teacher versed in song, and a smith, or gov, in his smithy. But a trevgordd herdsman was an indispensable of the hendrev, that is, the principal trev as contrasted with summer bothi on the mountains, and when engaged with his herd in summer on the mountains, his 3 indispensables were a bothi, his herdsman's dog, and a knife, and the 3 indispensables of his bothi were a roof tree, roof-supporting forks, and watling, and he was at liberty to cut them in any wild wood he pleased. So far, then, as the pastoral element was concerned, the trevgordd was occupied by a little group of tribesmen engaged in dairy farming, having charge of cattle in a common herd, with a common bull, and under the care of a common herdsman and his dog. Custom, grown out of traditional experience of what a single herdsman and his dog could manage, had determined, it seems, the size of the normal herd. Thus, in the Gwentian Code, we are told that a legal herd of cattle is 24 kine, and custom tenaciously adhered to tribal rules in such matters. Thus, in the Denbigh extent, it is mentioned that the whole velata of Achwedloch was in manu domini, by reason of escheats and exchanges, and that a portion of it was let ad firmam to 9 firmari, each of whom held for a term of years 31 acres, with 1 bull and 24 cows, paying per annum 73 shillings and 4 pence, and rendering to the lord at the end of his term the said bull and cows or their price, together with the land and a house built thereon. Here, even in a case in which Henry de Lacy was introducing into Wales holdings and herds in severalty, and very possibly introducing English tenants, he adhered to the Welsh tribal rule of the 1 bull and 24 cows to the herd. So also in the survey of St. David's under the head Glaston in Breconshire, the number 24 of grossa animalia is spoken of as the usual number ab antiqua consuetudine, and in the arrangement of common pasture, 1 great animal is said to count as equal to 12 sheep. The normal herd of the Trefgordd was then 24 cows, or their equivalent in bullocks and sheep. During the summer months, the herdsman living out on the mountains was responsible with his dog for the cattle of the Trefgordd, and his dog was worth as much as a cow or an ox, if it was one that will go before the herd in the morning and behind them in the evening, and make 3 turns round them in the night. Having no cattle of his own in the herd, the herdsman's testimony as to whose cattle were injured, and as to whose cattle had done the injury, was held, when such cases arose, to be sufficient to make the owner responsible, while as regards injuries done by the cattle of one Trefgordd to those of another, there was joint responsibility. There is common sense in such rules to begin with, and then, having grown into custom, they become perpetuated when custom is codified. The Trefgordd possessed further a common churn. This implies that the milk of the cows was thrown altogether into this one churn, as in Swiss mountain communes now. One of the dues from a Teog Trev, i.e. a group of non-tribesmen, was a cheese made from a day's milking of all the cows in the herd, so that we note in passing that the Teog Trev, i.e. of non-tribesmen, also had its herd and was in fact a Trefgordd. In winter the cattle came down into the lowlands and grazed on the pastures near the tithins or homesteads of the Trev, and as each of these had its corn and cattle yard, we may conclude that each owner penned in his own cattle at night during the winter months, or joined with some other tribesman who had a homestead in doing so. The rules as to the divisions of the tithins probably referred to these winter homesteads, so held in quasi-severalty. We need not dwell upon the common oven. Every hamlet in Brittany possesses its common oven to this day, often in the middle of the village green. Nor need we more than mention the common plough, to the team of which the tribesmen contributed oxen for the kvar, or common ploughing of the portion of the waste agreed upon for each year's corn crop. The attempt to realize what this practical unit, the Trefgordd, was, will not be thrown away if it should help us to understand how easily it lent itself to the arrangement of the chieftain's food rents, or tribute in after times of taxation. Granted that some such system of Trefgords or clusters of Trefgords pretty generally prevailed, having grown up as a matter of convenience in a grazing community, it is obvious how easily it might become the unit of tribute or taxation. Just as in the Doomsday Survey the number of ploughs affords such a unit, so in a tribal community a district must easily be fiscally estimated at so many herds, or so many churns, or so many ploughs. All these would mean so many Trefgords, and whatever the relations of the Trefgord to the velata of the surveys might be, and however much or often the actual residents with their herds might be shifted from one district to another, the district, as in the Denbigh extent, would remain the permanent unit for payments. In the early stages of tribal life, when the chieftain of the tribe moved from one district to another and received his food rents in the actual form of the night's entertainment, each customary place of encampment in his annual progress would become the centre at which the food rents would be paid and services rendered for as many nights' entertainment as his accustomed stay in the place. In later stages, when the chieftain's dues were commuted into money, the tunk pound, in lieu of food rents, easily became, as we find it in the surveys, a charge on the district rather than on the shifting tribesmen and their herds. And when the power of the chieftain had grown with time, and instead of nights' entertainments, obtained in the primitive way by the actual movement of himself and his retinue from place to place, the food rents or the tunk pounds in lieu of them were delivered at his palace, he would become the recipient of a regular revenue. And out of this revenue it would become easy for him to reward a follower or endow a church by the transfer of so many food rents or tunk pounds in lieu of them, or the revenue from such a such district, or of so many of its trevgorths, without disturbing the internal working of the system or the daily life of the tribesmen and their herds. When Beowulf returns to his chieftain after his exploit, and is rewarded by the gift of a palace and so many thousands, we naturally ask of what, and how it could be done. We may not be able to say off-hand what the unit was, but we get from the Welsh example some rough idea of what tribal tribute and income were, and how these could be readily gathered and transferred. The method of payment of galanas between kindreds. Postponing for a while the consideration of the position of the various classes of non-tribesmen, but still keeping in view the fact that in considerable numbers they were practically sharers with the tribesmen in the rights of grazing and occupation of land, we are now in the position to realize to some extent what happened when a murder had taken place. If it was of someone within the kindred, there was, as we have said, no slaying of the murderer. Whether it were a parricide or a fratricide, or the murder of a near kinsman, under Cymric custom there was no galanas, nothing but execration and ignominious exile. But if a tribesman of one kindred were killed by a tribesman of another kindred, then it was a serious matter of blood feud between the kindreds, or of the payment of the blood fine. The tribal conscience demanded vengeance or composition. It sometimes happened that the murderer had fled to a church for safety, taking his cattle with him. For the clergy or monks at the place of refuge had a herd of cattle of their own, and with them the murderer's cattle were allowed to wander and graze so long as they returned nightly to the refuge. There he remained, presumably till the kindred of the murdered tribesman, through negotiation and arrangement of the chiefs of the kindreds, had agreed to accept the payment of the galanas, if it were the case of an uchelor or full tribesman, of 126 cows. 6 cows, as we shall see hereafter, were sarad for the insult, and 120 cows galanas for the murder. The sarad was paid first. 6 cows or other cattle to the same value belonging to the murderer were driven from the herd in payment. The murderer's life was then safe, and presumably he might return with his cattle to his place. Within a fortnight, the tribesmen of the murderer's kindred met to apportion the payment of the rest. They came from trevgorths far and near, from the territories sometimes of various higher territorial chieftains within whose districts they had grazing rights. The collected tribesmen having apportioned the payment, fortnight after fortnight instalments must be paid till the whole number in value of 120 cows was completed. But by whom was the payment to be made? 40 cows must first be found by the murderer, his father, mother, brothers, and sisters with him. They doubtless helped one another, but theoretically in one or other of the common herds there must have been cattle belonging to the murderer, his father, mother, brothers, and sisters, or how could they have paid their shares? There was nothing unreal in this liability of each to pay a share, for had the murderer been slain, each one of them would have received, instead of having to pay, a share in 40 cows. The murderer himself had to pay a third of the 40 cows if he had them. His father and mother between them paid the next third, and the brothers and sisters the remaining third, the sisters paying half what the brothers did. Footnote. Sisters paid for their possible children, and if these children were of age, they paid instead of their mothers. After the age at which they could not have children, the sisters did not pay. That the daughter after 12 was independent of her father with da of her own. End of footnote. The herds of many a trevgorth must be thinned before this could be done. The remainder of the galanas, that is, 80 cows, fell on the kindred to the 7th degree or 5th cousins. The paternal relations had to find 2/3 of it, and the maternal one 1/3, and these kindreds embraced the descendants from the great-grandparents of the great-grandparents on both sides. In the first fortnight, the kindred on the father's side had to find half what was due from them. In the second fortnight, they had to find the other half, and in the third fortnight, the maternal kindred had to find their share, till so at last the full tale of the 120 cows was paid. The oath of peace from the kindreds of the murdered man could then be given, and the murderer and his kinsmen be at peace. But what happened if the murderer could not find the cattle for his third of the 40 cows which he and his immediate family had to find? He had yet a right, as a member of the greater kindred, to claim in aid a spear penny from all those male kinsmen descended from a common ancestor on his father's side 2 steps further back, i.e., still more distantly related to him than those included in the kindred to the 7th degree who had already paid their share. Even if the slayer were a woman, she had the same right of spear penny from the men of her kindred to help her make her payment. So this attempt to realize what was involved in the payment of an ordinary case of galanas brings us back to the recognition of the double aspect of the kindred in the structure of tribal society: its solidarity and joint responsibility on the one hand, as against outsiders, the whole kindred being responsible in the last resort; on the other hand, the individual responsibility of its members, graduated according to nearness of relationship for the crimes of their relative. In Cymric tribal society this was made possible by the broad fact that both males and females in the group of kindred, on both paternal and maternal sides, liable to pay, had cattle of their own in the common herd, each having received his or her dar for maintenance, by right of kin and descent from the common ancestor or chieftain of the kindred. The two things surely hang together, and therefore if we find in the laws of other tribes somewhat similar rules regarding the payment of wergelds, it probably will be worthwhile to inquire further whether the corresponding structure of tribal society, or something more or less equivalent to it, may not be present also. End of section 4.